someone out there with a 14-year-old needs to have them. We need a lawyer to draft the best affidavit in the world about that 14-year-old's intent to purchase on the day they turn 18. And it needs to be highly specific, such that a case is going to be found to be ripe because
You got to still have standing.
you got to have standing.
We are the Armed Attorneys. Today we're talking about a circuit court of appeals upholding a ban on the purchase of firearms. Now we see, and we're going to talk about kind of a lot of cases here and see where we're going with this. Is it going to the Supreme Court? But before we begin, show your support for the Second Amendment by hitting that like button. Now, this case originated out of the state of Colorado, and it related to 18, 19, and 20-year-olds purchasing firearms, and the state had a ban on this. And so we challenged it, and where we're at.
Well, we're in a sad place, and I will say, children right now are not on my good list because I am once again sick because of my children.
Sure.
And yet, I still believe that an 18-year-old has the right to purchase any firearm they damn well choose.
Yeah.
But we are not in a good place because, unfortunately, this case went up to the 10th Circuit, who weaseled their way.
We're talking about a lot of weasels on this one.
So many weaseled their way right out of a decent Bruin analysis, because a decent Bruin analysis says that 18, 19, 20-year-olds have to have the right to purchase firearms.
Yeah, so we'll throw the case up there. So this is Rocky Mountain Gun Owners versus Polis. This is out of the 10th Circuit. We'll throw the opinion up there. But ultimately, the weasel in this case is they completely sidestepped the Second Amendment. They held that the law presumptively fell outside of the scope of the Second Amendment and the right to keep and bear arms. It seems like purchasing would be integrally tied into keeping and bearing.
Well, yes, it has to be. And that's, a recall back, 6 months now, we were discussing, maybe more, we were discussing a case in which the courts did a similar sidestep with regard to city ordinances about where you could have gun ranges, and said training is not in, like, the Second Amendment is not implicated by whether or not you can be proficient. To say that purchase is not implicated is even crazier, but yet not surprising if you want to restrict someone's right to keep and bear arms.
Yeah, and just to kind of take a little bit of a survey before we talk about the path to the Supreme Court, we see other cases out there. I found a really interesting case out of the Fourth Circuit. We'll throw that one up on the screen. And this actually came pre-New York State Rifle and Pistol Association v. Bruin. So Fourth Circuit talking about a Missouri law, and they struck down their purchase restriction ultimately. And this is, all right, we talked about the weasels. This is a crazy one because the appeals court ordered the lower court to issue a mandate. Before the mandate was issued, the plaintiff turned 21. The court mooted the action. They tried to add in some more plaintiffs and appealed it back up to the Fourth Circuit, and they vacated their opinion. And so, is this a binding opinion on the Fourth Circuit anymore? No, because they vacated their opinion. I think it's very, very persuasive. Obviously they use a different framework than New York State Rifle and Pistol Association, but there's a lot of, you see how courts were reaching this conclusion even without that framework that we have.
Right. And that bothers me in particular, because imagine that the day you turn 18, you go, you want to buy, let's say, you want to buy a handgun. You want to protect yourself. You go, you try to buy a handgun, you get turned down, you file your lawsuit that same day. And you say, I have a constitutional right to do this. I'm challenging this under New York State Pistol and Rifle versus Bruin. Well, by the time that case is, I don't know, maybe even going up to the circuit court for the first time, you've probably already aged out. That's how long it takes. And at that point, the court's going to say, moot. Yeah, you're old enough to buy a gun. And so we're never going to have this case fully litigated if they do that.
Well, whatever happened to a right delayed is a right denied? Because that's really what they're doing here, is they're putting people through the ringer, and then, oh, look, you're not harmed anymore, so you go nuts. Everybody else, you want to jump through all these hoops, pay all these thousands of dollars in legal expenses just to have the same result? Good luck. How are you supposed to secure your rights otherwise?
No, you can't. It's really unjust. And I think there's no way to expedite it. I mean, if you could, even the Supreme Court will moot stuff unnecessarily such that they don't have to touch it. Even our good, wonderful Supreme Court that we're all very happy with right now, they would still moot this.
Yeah.
It's infuriating. I don't know what we do.
So the next obvious question becomes, hey, are we going to get relief from the Supreme Court of the United States on this? Well,
I just gave you my answer on that.
I'm hopeful, but there's a few cases right now where I think we could say, all right, we have a conflict of laws. We have the Eighth Circuit with their licensing saying, hey, guess what? You got to give your licenses to 18, 19, 20-year-olds. This age restriction on violates the Second Amendment. Okay, maybe that's not a dead ringer to create this split. We had actually a similar case out of the Fifth Circuit that got resolved before anything really happened. So it's really only binding on Texas. But in researching this, I found 21 cases on appeal. That's ironic. 21 cases on appeal dealing with the purchase restriction on 18, 19, and 20-year-olds from all over the United States. So are we going to get a circuit split on this? Yeah, it's going to happen.
If we can get them through, here's what we need to do. You need someone out there with a 14-year-old needs to have them. We need a lawyer to draft the best affidavit in the world about that 14-year-old's intent to purchase on the day they turn 18. And it needs to be highly specific such that a case is going to be found to be ripe because
you got to still have standing.
You got to have standing. And so then we'll go ahead and start litigating it now so that hopefully in 7 years we've actually...
When they're 20 years old.
When they're 20 years old, we've litigated it fully enough and we get an answer. So, round them up. Round up your 14-year-olds. Let's go.
Yeah, and what's so tragic about that Fourth Circuit case where they vacated their own opinion, they lay out such a good argument about when do your constitutional rights vest? Is it 14? Is it 15? Is it 16, 17, 18? Well, we know they do it at some point, right? At some point you have your full Second Amendment rights. And have we seen a court on any level draw that line such that we all know where we're at? Because ultimately, until that question is resolved, I think we're going to continue to see these problems. I have to imagine that the Supreme Court's going to get involved.
I disagree. I disagree that the Supreme Court has to get involved. I want them to get involved.
Yes.
But I think
I was wondering where you're going with
that. The tendency to weasel.
Yeah.
Weasel's going to weasel. And I think that this is one that they could shimmy out of and be like, look, that's mooted. And we got all these other...
How many years does it take to get to the Supreme Court?
Exactly. So, I think that, more than 3, right? It's more than 3. So, I think that there's so many other Second Amendment cases to be litigated that this is just not, I don't think it's going to hit their radar. I think they're going to find a good reason not to take it up.
Yeah.
There, I made my decision. Solidified.
Well, the ongoing joke, obviously, Donald Trump watches the channel. Verified show watcher.
Verified.
But the obvious place to start with this is, well, we have that one restriction that kind of seems out of place here with handguns for 18, 19, and 20-year-olds from federal firearms licensed dealers. I think that's some low-hanging fruit. We've been talking about a lot of this stuff going around. And then how does, ultimately, we got to get state law in check.
Right. So that's here. So what happens is we amend the federal law. We say 18, 19, 20-year-olds get to purchase handguns from FFL dealers. And then whoever sues over that...
Or they're arresting the FFL, I imagine.
Yep. Whoever sues over that, then we actually litigate whether 18, 19, 20-year-olds have a constitutional right to purchase firearms whenever they want. And we shoehorn that into the ultimate issue that the courts have to decide. And there we go. I fixed it.
And that's more than a 3-year window.
That is more than a 3-year window.
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And as always, question and comment for us below. Until next time, we're the armed attorneys.